Welcome to our discussion on employment law, focusing specifically on equal opportunity in the workplace. Equal opportunity is a crucial legal framework designed to ensure that every individual is treated fairly and without discrimination when it comes to employment. This means that businesses and organizations must comply with laws that protect employees and job applicants from bias based on factors like race, gender, age, or disability. Understanding these protections is key to fostering fair and inclusive workplaces and ensuring that business practices align with both legal requirements and ethical standards. Throughout this presentation, we'll explore how these laws operate within the broader context of business and organizational management to support equality and fairness at work. Let's take a closer look at the legal foundation of employment law, starting with the landmark Civil Rights Act of 1964. Title VII of this act is crucial because it prohibits employment discrimination based on race, color, religion, sex, and national origin. This was a major step forward in ensuring fairness in the workplace. To enforce these protections, the Equal Employment Opportunity Commission, or EEOC, was established. The EEOC plays a vital role by investigating discrimination charges, pursuing legal remedies when necessary, and providing guidance to help employers comply with the law. Over time, the original provisions have been expanded through later amendments. These subsequent laws broadened the scope of protections, strengthened enforcement procedures, and clarified both employer responsibilities and employee rights. So when we talk about the statutory framework of employment law, it's important to understand that rights begin with statutes like the Civil Rights Act, the agencies like the EEOC that enforce them, and the amendments that refine and enhance these protections. This foundation is key to ensuring a fair and equitable workplace for everyone. Title VII of the Civil Rights Act of 1964 is a cornerstone federal law that protects employees from discrimination in the workplace. It strictly prohibits employers from making decisions based on race, color, religion, sex, or national origin. This means that hiring, firing, pay, promotion, and other terms and conditions of employment must be free of discriminatory practices. The law is applicable not just to private employers, but also to government entities and labor organizations, as long as they meet certain coverage thresholds. Enforcement is handled by the Equal Employment Opportunity Commission, or EEOC, which investigates complaints, oversees administrative processes, and can pursue civil litigation if necessary. Overall, Title VII serves as the fundamental federal safeguard against employment discrimination. Title VII's coverage extends beyond just direct employers, influencing various parts of the employment process. First, it generally covers private and public employers with 15 or more employees. This means that if a company meets this size threshold, it must comply with Title VII's protections against discrimination. Next, employment agencies are also covered. These agencies are prohibited from screening, referring, or classifying applicants in a discriminatory way, ensuring fair treatment even before a person reaches the employer. Labor organizations or unions are another important category. They cannot exclude or segregate members or otherwise disadvantage them based on protected characteristics. This promotes fairness within union membership and activities. Lastly, joint labor management programs, such as apprenticeship and training programs, must provide equal access and treatment to all participants. This ensures that opportunities for skill building and advancement are available to everyone without discrimination. It's key to remember that liability under Title VII follows the employment relationship, encompassing these various groups involved in the hiring and employment process. This broad coverage helps protect individuals throughout their work experience. Title VII of the Civil Rights Act establishes key protected classes that employers must recognize under federal law. These include race, which covers protections against discrimination based on an individual's racial background or characteristics. Color refers to discrimination based on skin color or complexion. Religion protects individuals from bias due to their religious beliefs or practices. Sex includes protection. Here we see that equal employment protections go beyond just Title VII. Several additional laws safeguard various protected classes to ensure fairness in the workplace. First, the Age Discrimination in Employment Act, or ADEA, protects workers aged 40 and over from discrimination. Then, the Americans with Disabilities Act, or ADA, prohibits discrimination against individuals with disabilities. The Genetic Information Non-Discrimination Act, or GINA, safeguards against discrimination based on genetic information, which is increasingly important as genetic testing becomes more common. Pregnant employees also have specific protections under the Pregnancy Discrimination Act, or PDA. Importantly, recent interpretations, like the Bostock decision, have expanded protections to include sexual orientation and gender identity. Lastly, military status is protected under the Uniformed Services Employment and Reemployment Rights Act, or USERA. Together, these laws demonstrate that equal opportunity law covers a broad spectrum of protections beyond just Title VII. On this slide, we're diving into two key forms of discrimination in employment law. First, we have intentional discrimination, also known as disparate treatment. This happens when an employer consciously treats someone differently because of a protected characteristic, like race, sex, or religion. For example, refusing to hire a qualified candidate simply because of their race is clear intentional discrimination. The second form is unintentional discrimination or disparate impact. This occurs when a seemingly neutral policy or rule ends up disproportionately affecting a protected group, even if there was no intent to discriminate. A common example is using a strength test that unnecessarily excludes many women, even though the job doesn't require that level of physical strength. Both paths, whether intentional or unintentional, are prohibited by law, emphasizing the principle of equal opportunity for all individuals in the workplace. It's important to understand these distinctions because they help shape fair and inclusive hiring and employment practices. On this slide, we're focusing on intentional discrimination, often referred to as disparate treatment. This occurs when an employer deliberately treats a job applicant or employee less favorably because of a protected characteristic, such as race, gender, or age. The key elements here are the employer's motive and decision-making process, which result in unequal treatment in critical areas like hiring, firing, pay, promotions, or disciplinary actions. Simply put, it's the conscious choice to treat someone differently based on their status. Importantly, direct bias of this nature is not just unethical, it is explicitly prohibited and actionable under Title VII. Understanding this concept helps us recognize when discrimination crosses the line into illegal territory. Here, we're focusing on a specific form of discrimination known as disparate impact, which is also called structural discrimination. This occurs when a rule or practice, even if it seems neutral on the surface and without any discriminatory intent, ends up disproportionately excluding members of a protected group. The key point is that this practice must not be job-related or necessary for business operations to be considered discriminatory. For example, a warehouse might use a strength test during hiring that rules out many more women than men. Even if the test seems fair, it could violate equal opportunity laws because the job itself rarely requires that level of strength, making the test unnecessary and unfairly exclusionary. This highlights why it's so important to carefully evaluate policies to ensure they don't unintentionally create unfair barriers. Now let's dive into the McDonnell-Douglas burden-shifting framework, which is crucial in employment law cases involving discrimination claims. At Stage 1, the plaintiff carries the initial burden. They need to present facts that establish a prima facie case, meaning they must show they belong to a protected class, are qualified for the position, have suffered an adverse action, and provide circumstances that suggest discrimination may have occurred. Once this is established, the burden shifts to the employer in Stage 2. The employer must then offer a legitimate, non-discriminatory reason for the decision in question. After that, the plaintiff can challenge this explanation by arguing that it's merely a pretext or excuse to cover up discrimination. Essentially, first there's an inference of discrimination, then the employer provides an explanation, This back and forth is what we call burden shifting, and it plays a key role in how courts evaluate these cases. Now let's talk about enforcement under the EEOC and how the agency handles workplace equality issues. First, the EEOC investigates complaints. They thoroughly review charges, gather all relevant facts, and assess the conduct of the employer involved. This is a critical step to determine if there's been a violation. Next, if they find sufficient evidence, the EEOC moves to enforce the law. This can take the form of issuing formal findings and potentially pursuing litigation or negotiating a settlement to address the issue. Another important role of the EEOC is mediation. Before things escalate to a lawsuit, they offer a voluntary mediation process to help resolve disputes in a less adversarial way, which often saves time and resources for all parties. Lastly, education is key in prevention. The EEOC provides guidance, training sessions, and compliance resources that help employers understand their responsibilities and create fair, equitable workplaces. Overall, federal oversight through these processes helps ensure that workplace equality is not only promoted, but actively protected. When an employee files a charge with the EEOC, the claim enters a specific administrative process designed to address the complaint thoroughly and fairly. First, the employee submits a formal complaint, which officially starts the procedure. Next, the EEOC conducts an investigation by collecting relevant documents, hearing statements, and getting responses from the employer. After gathering all this information, the agency makes a determination on whether there is reasonable cause to believe the allegation is valid. If reasonable cause is found, the case may move toward mediation or litigation, giving both parties a chance to resolve the issue outside of court or prepare for legal action. Finally, the process concludes with a resolution that could involve a settlement agreement, dismissal if the claim lacks merit, or the issuance of a right to sue notice for the employee to pursue the matter independently in court. This structured path ensures each claim is carefully considered before reaching a final outcome. When we talk about liability in a business context, it's crucial to understand how the organizational structure impacts who is responsible for employment practices, especially when it comes to unlawful discrimination. Starting with a sole proprietorship, the owner and the business are legally considered the same entity. This means that if there's discriminatory hiring, firing, or harassment, the owner's personal assets could be at risk because they're directly exposed to any legal claims. Next, in a partnership, liability can be shared among partners, particularly if employment decisions are made by or on behalf of the firm. So partners might be held accountable for discriminatory acts, even if they didn't personally make the employment decisions. With corporations or LLCs, the company itself is usually the employer. However, managers and agents within the business can still create significant exposure to equal employment opportunity claims. This could happen through the policies they enforce, the way they supervise, or their conduct in the workplace. It's important to note that having limited liability as a corporate structure does not eliminate exposure to employment law liability. This means the risk and responsibility related to employment practices are shaped heavily by the business structure, but no structure completely shields individuals from accountability when it comes to discrimination issues. When an employer faces allegations of discrimination, they have several defenses they can use to justify their decisions. One key defense is the bona fide occupational qualification, which means that a protected trait must be essential to performing the job itself. For example, certain roles might require specific characteristics directly related to job duties. Another common defense is a legitimate non-discriminatory reason. This means that the employer's action was based on things like job performance, conduct, or other lawful reasons unrelated to discrimination. Employers can also rely on a seniority system, where differences in treatment arise from a neutral and established seniority structure, rather than discriminatory intent. Lastly, business necessity is a defense used when a policy that affects employees is directly related to the job and necessary for the operation of the business. It's important to remember that not every unequal result automatically means unlawful discrimination. These defenses help clarify when decisions are fair and lawful in a business context. On this slide, we're focusing on the concept of equal opportunity, particularly through affirmative action and the notion of reverse discrimination. Affirmative action is essentially a remedial tool. Its purpose is to create policies that expand opportunities for groups that have been historically excluded or marginalized. Legally, affirmative action is allowed, but only in limited circumstances where it aims to remedy past discrimination or address important governmental interests. The key intent behind affirmative action is to increase inclusion, but it's important to note that it does not mean race or sex should become automatic deciding factors in decisions. Instead, it's about considering these factors thoughtfully to promote fairness. Now, on the flip side, we have the concept of reverse discrimination. This describes claims that members of majority groups have been unfairly disadvantaged by decisions that give preference to others. Legally, Title VII protects all individuals from intentional discrimination, no matter their group status. Courts pay close attention when explicit preferences are made. Quota-like approaches, which set fixed numbers for certain groups, are particularly risky and often face legal challenges. In summary, the law permits remedies to address discrimination, but it does not allow unchecked preference. This balance seeks to promote equal opportunity while ensuring fairness for everyone involved. Sexual harassment is recognized as a form of discrimination under Title VII, which means it's taken very seriously by employment law. One key concept here is the idea of a hostile work environment. This happens when unwelcome sexual conduct is so severe or happens so often that it changes the very conditions of your employment. It creates a workplace that feels intimidating, hostile, or abusive. Importantly, conduct like this can be considered discriminatory even if it doesn't cause any direct economic loss, such as a demotion or a pay cut. The impact on the employee's work environment alone is enough for it to be unlawful. Understanding this helps us recognize the importance of maintaining a respectful and safe workplace for everyone. When an employee reports discrimination or takes part in an investigation, the law strictly prohibits any form of retaliation. This means that protected activities like filing a complaint must never lead to punishment. Retaliation can take many forms, such as termination, being demoted, or reassigned to a less desirable role. It might also involve cuts to pay, a reduction in hours, or the loss of important opportunities. Even threats, intimidation, or being blacklisted fall under retaliatory actions that are unlawful. It's crucial to understand that reporting bias or discrimination should never result in any negative consequences for the employee. Protecting employees from retaliation helps maintain a fair and respectful workplace for everyone. When it comes to compliance, there are several best practices employers should follow to create a fair and respectful workplace. First, having a clear EEO policy is essential. It should plainly state state-protected rights and ensure that standards are applied consistently across the board. Regular training is also key. Both managers and staff need to stay informed about their duties and the proper procedures for reporting issues. Next, complaint procedures must provide safe and accessible channels for reporting concerns, and any complaints should be investigated promptly and fairly to maintain trust. Documentation plays a critical role as well. Employers should carefully record hiring decisions and disciplinary actions, making sure all evidence is objective and dated. Finally, diverse recruitment strategies help broaden candidate pipelines, and using neutral job criteria supports fairness in hiring. Overall, prevention is definitely stronger than defense. By implementing these best practices, employers can foster a more inclusive and compliant workplace environment. When we talk about legal exposure and compliance, it's crucial to understand the significant risks that come with non-compliance. Failing to adhere to regulations can lead to financial penalties, regulatory scrutiny, and serious damage to your brand's reputation. One major area of concern is civil liability, which can result in back pay, compensatory damages, punitive damages, and even hefty attorney fees. Private lawsuits, in particular, can be very costly. On the regulatory front, agencies like the EEOC can take actions that include investigations, conciliation efforts, ongoing monitoring, policy changes, fines, and mandated training programs. These enforcement actions often lead to structural changes in how a business operates to prevent future violations. Reputational damage is another critical issue. The consequences here tend to be long-term and can erode your brand's strength, make hiring more difficult, foster employee distrust, and invite public scrutiny. Importantly, the impact on reputation usually lasts much longer than the legal proceedings themselves. Ultimately, compliance with equal opportunity employment laws is not just about avoiding penalties. It's about maintaining the integrity and success of your business. Understanding these risks helps us navigate the law of business and business organizations more effectively. To wrap up, equal opportunity is much more than just a legal requirement. It's a powerful competitive advantage. When organizations embed equal opportunity into their core values, it transforms compliance from a mere obligation into a thriving culture, and that culture directly boosts performance. From a legal standpoint, practicing equal opportunity reduces risks by ensuring employment decisions are consistent and lawful. Ethically, it safeguards the dignity and fairness every employee deserves, fostering trust throughout the workplace. But beyond law and ethics, there's a clear business benefit. Organizations that genuinely commit to equal opportunity attract stronger talent, build a solid reputation, and create lasting value. In essence, aligning law, ethics, and strategy around equal opportunity creates inclusive cultures that drive stronger, more successful organizations.